Good evening. This is Saugus Board of Appeals, a continued hearing. I always forget the address, 960, 961, is that it?
961, 999.
All right, thank you. 961 to 999. It's a continued hearing. I just want to state that this hearing is being recorded. Let's start with the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd also like to swear anyone who may speak tonight in. Promise to tell the truth, whole truth, and nothing but the truth, so help me God. Repeat after me, it doesn't look like anyone's. If you may speak tonight, please take the oath. I promise to tell the truth, the whole truth, and nothing but the truth, so help me God. And we can start off with the petitioner's attorney.
Good evening, Mr. Chair. For the record, Paul Haverty, Blattman, Bobrowski, Haverty, and Silverstein representing the applicant. I did submit to the board on July 28th a letter addressing the outstanding parking issues left over from the last meeting of the board. I can run through that really quickly if you'd like me to.
Yes, I think that would be great.
Okay. So it's our position that the project as proposed complies with the shared parking requirements. So as I set forth in my letter, the requirement for the shared parking at the greatest amount is 355 spaces, of which 165 spaces would be required for the office use. The combined parking spaces for the two properties are 384, which exceeds the total number of spaces required. Therefore, it's our position that we comply with the shared parking requirements. Now, I know that Board's Counsel Attorney Schomer had indicated that he believed that the bylaw would not be applicable because the parking lot, in his interpretation, needs to be available for each use on each lot. But there's nothing in the bylaw that suggests that. In fact, if you took the bylaw to an extreme, you could locate the entirety of the required parking on one lot with zero parking on the other lot. There's nothing in your bylaw that indicates that that would not be allowed. And it would still be considered shared parking, even though one of the properties is not providing any spaces and the other property is providing all of them. It would still meet your requirements as long as the total number of spaces as set forth in the chart in the bylaw is provided between the total of the two lots. So that's exactly the situation that we have here, and we strongly believe that the parking meets your shared parking requirements. Another of the reasons that Attorney Schomer felt that the parking spaces did not meet the shared parking requirement is that, in his interpretation, they are not under the same ownership as that is required under your bylaw. But in fact, these two properties are owned by entities controlled by the same person, Mr. Palumbo. In any zoning interpretation of ownership of common lots, which is something that is, there's dozens and dozens of cases interpreting whether lots are held in common ownership, and the distinguishing factor is always control. So if one party has sufficient control over both lots, then those lots are determined to be held in common ownership for zoning purposes. So it is our opinion that the ownership aspect of the bylaw should be interpreted in accordance with the standard definition of common ownership under zoning, and therefore we believe that we comply with that provision of the bylaw. Now, despite the fact that we strongly believe that we comply with your shared parking requirements, we also note that the board has the authority to grant a waiver of the parking requirements. Now, we understand they don't have an authority to grant a waiver of the required parking for the office use, so there has to be a minimum of 165 spaces available at the office. If we're not using the shared parking, that would mean that there's only 49 extra spaces at any point in time. So that would limit the total number of spaces to 219, I believe it is. 219 parking spaces. So we would request a waiver of your parking requirements down to 219. But I also note, and we do have our engineer Sean Reardon with us, that there is room to add additional parking. An additional 39 spaces could be added along the access road, which if constructed would provide a total of 258 parking spaces. We don't think that's necessary. We're well aware that there's ample parking available in the office lot. We don't think that we'll ever need to construct those spaces, but we would certainly accept a condition that those spaces be land banked and available if it proves necessary. Then the final issue that was brought up at the last meeting that I wanted to address had to do with the need for the submittal of a definitive subdivision plan rather than having the board issue, simply endorse an A&R plan. And Attorney Shoma believed that the board did not have discretion to issue A&R approval because the project does not meet frontage requirements, but we're requesting a waiver of the frontage requirement. And we strongly believe under Chapter 40B that is a waiver that the board is certainly within its rights to grant. And once granting, it would then have the authority to endorse an A&R plan. And there is case law that supports that, Lever Development versus West Boylston Zoning Board of Appeals, which ordered the endorsement of an A&R plan for a lot with limited frontage. I will also note that there's not a lot of Housing Appeals Committee case law addressing A&R approvals, but there is one that I was involved in down in Falmouth, where a developer didn't even submit an A&R plan during the course of the public hearing. I was representing the board. I advised the board to include a condition that simply stated that they were required, as part of their submittal of final plans, to submit an A&R plan for the board to endorse, which seemed like a pretty benign condition. The developer objected to that condition at the Housing Appeals Committee, and the Housing Appeals Committee struck it and said that that should have been part of the decision that was issued by the board, which I don't know how it could have been because the plan wasn't submitted. But the Housing Appeals Committee, takes a very strong stance that all relief should be granted as part of the original hearing process. So that's our position as it relates to parking. I'm not aware of any other outstanding issues that we need to discuss, but I'm certainly happy to take any questions.
Attorney Shoma, you have any questions, or
I do not.
do you feel you're satisfied with the parking situation now?
As I explained the last couple of times we've discussed it, it's a matter primarily, I think, of how the board's decision is drafted in terms of conditions, in terms of what the developer will need to do to ensure zoning compliance for the non-40B parcel. So we can address that when we get into writing the decision, but I'm satisfied now.
Okay.
Based on what I've heard,
Okay.
and was before the applicant's
Okay,
attorney's letter.
Make sure. Do you see the necessity to bank those spaces?
I would say that's for the board's determination.
Okay.
If you feel that the parking is insufficient as a matter of fact, whether there actually is enough parking spaces, then that's something you should consider. But the testimony that you've received on this question from your peer review consultant has indicated that he was satisfied with the number of parking spaces.
All right, so the banking really might not be necessary, according to the peer review.
We haven't heard specifically from the peer reviewer on that question, but he's satisfied that the number of spaces is adequate. I think his concern more has to do with the management of the shared parking arrangement. So that's where the devil is in the details in terms of conditions.
Okay,
But Mr. Chair, we certainly wouldn't have any objection to the board including a condition requiring a
Right,
plan
it does
showing
seem
those
something
spaces be
you can
submitted.
certainly work through it.
Yep.
In conditions. Any comments from the board?
The issue of the definitive subdivision versus A&R, are you satisfied with that explanation?
So I disagree with the attorney's interpretation of the requirements, but I don't think this is a matter that's something that the parties need to be concerned with presently. The board has the authority to endorse plans, whether it's approval not required plan or a definitive subdivision plan. And the board has that authority regardless of the project. In this situation, the case law, it doesn't have anything to do with Housing Appeals Committee. This is a planning board matter. So under the subdivision control law, which Peter, which you're very familiar with, having been a former planning board member, you'll recall that even if a parcel has a variance from the zoning board of appeals for frontage, that doesn't give the planning board the authority to endorse a plan as approval not required under the subdivision control law, because the way the subdivision control law works is it's entirely separate from what is granted in terms of zoning relief under the local zoning bylaw. So the subdivision control law specifies that all of the parcels in a Form A or A&R plan have to have adequate frontage regardless of whether it has a variance from the zoning board of appeals. So my opinion is that that would apply whether it's a variance granted by this board under Chapter 40A or a waiver granted by the board under Chapter 40B. The fact remains that the parcel does not have frontage. It's a distinction without a significant difference because all it means is a plan that the applicant will need to provide the board to endorse will have the words definitive subdivision plan rather than approval not required. It's the same.
So again,
Essentially the
something
same
that you,
thing. And to be clear, there wasn't a discussion suggesting that the applicant would need to go to the planning board for that. The board does have the authority to issue that endorsement, whatever the plan is called.
so that's something you could also work through.
Yes, I mean, if your decision requires us to submit
You can work through
a
it.
definitive subdivision plan rather than an A&R plan, we're not going to object to that.
Any other questions from the board?
Just with regard to the parking and this land bank and sort of future proofing, should more spots become available, I would like to add that as a condition once we get to it. Sounds like the applicant is amenable to it, so I want to add that when we get there. One of the other things we talked about last time was a condition to pay for pre-blast surveys for residents within 500 feet of the zoning blasting area. Sounds like, I think there was discussion, you're amenable to that?
Yeah, we're happy to provide, first of all, we're required to provide, I think, within 300 feet. 250. So from 250 to 500, we're happy to extend that offer to any residential houses, within that area, but not to businesses.
Understood, thank you.
That's
On that,
It's from the blasting,
Single-family residences
from the blasting.
or duplexes, I
correct,
guess.
so like
the
the
blast
hole in
site.
the ground for the blast, not the property line.
Not the
itself.
property.
no, it's on the blast site.
Yeah.
And who determines that? That
So the way it works is the blaster will contact everybody that's on whatever the list is that, they'll do the circumference and identify all of the properties that are required to be notified. They'll notify them, give them the option of having their house surveyed, and if they agree to it, they'll come in and they'll do the survey.
But it will be the blasting company that will do the notification
Correct.
and determine who's in that.
And do the survey as well.
Into the fact, okay.
Yep.
Anything else
It's gonna be
immediately?
main blasting.
Probably. I don't know for sure. But yeah, main drilling and blasting is, one of the biggest outfits.
Yeah, they do most of the work around.
Yeah.
Anything else on the board? You can get into
What-
other things.
Were there any other
Yes,
were there questions for our civil engineer who is also here? We
Right.
can answer anything as well.
There's gonna be a condition, because I know, regarding landscaping the front of the property,
Yeah.
out on Route 1.
I know it seems like it's foregone conclusion, Mr. Ridden mentioned it last time. And I don't have any reason to doubt it, but I don't think we have any letter from the fire department about a truck turnaround yet.
We actually, you did receive a letter.
It was actually a copy of an email
Yeah,
from Captain Phelan.
Okay,
Yeah.
fine.
yeah. Did you receive that? I can make sure you get that.
I don't recall seeing it.
Oh, we've all seen it.
Chris, the email, and I can forward it to you, it says, the emergency access for our ladder truck is acceptable as per our phone call. We've agreed that the curb radii will be lessened to allow easier access and exit, widen median gap at entrance drive. All changes can be made on the final plan, so you can continue on with the project.
And that's from the fire department.
Yep, and that's Captain Bailey.
Thank you. That's all I have.
Anything else from the board? Yes, ma'am.
In regards to the construction management, I know it was mentioned that you guys will be installing 50 feet of riprap prior to the entrance to Route 1 to clean the tires and potentially a tire wash station. Have you guys decided on a tire wash station to prevent debris from entering the roadway?
I haven't gone that far yet. I would imagine on this site, because it's predominantly rock, we're going to have very little mud to worry about, but
Okay.
that would be definitely something that's worked out in coordination with the building department during construction.
But one of the draft conditions does have a requirement of a pre-construction meeting with town staff to go over, those sort of details. So that's something that can be addressed at that time.
And just on that, again, that roadway's mass highway, so if there are any issues related to tracking sediment, we'll have to deal with them as well.
Okay.
We have Mr. Baldwin.
Mr. Riley?
We have Mr. Baldwin with us. We have our town engineer, Mr. Baldwin.
Yeah. Yes, Mr. Baldwin.
Just,
Oh, all right.
when you get to be,
We'll get to you, yeah.
I don't have anything else, so if you don't have any more questions, I'll take a seat
You
and
take a seat for that.
Mr. Chair, through you, may I ask one question of the applicant?
Yes.
Does the project trigger a MEPA filing?
No, it doesn't. We're below the threshold for transportation and all the other land thresholds.
Mr. Baldwin, did you have some questions?
kind of. We have draft conditions that we've been working on. There's some follow-up questions. to that.
Okay.
Do you want me to come up to the podium?
Sean, you want to start with those conditions and?
Sure. Todd and I talked quite a bit about, first we had, as part of our responses, we had committed to including conditions in the decision. So what I agreed to do is to take all of those commitments that we made in our response letters and put them in the form of conditions, and then we provided those conditions to Attorney Schumer. Todd had about 11 more additional conditions. We added those, and so those have all been provided to your attorney for inclusion in the decision.
Okay.
I have all those.
There were 22 in total.
And just to clarify, because we had previously submitted the draft decision, we decided not to add those conditions into the decision and simply submit them directly to Attorney Schumer, just in case he had already made changes to the draft, and I just didn't want to make it more difficult for him.
Okay. Anything else on the board right now? Any comments from the audience? Yes,
I have a few things that.
that must come to the podium.
I have a couple of line items that some of my resident customers surrounding abutters have just kind of shout out because they couldn't be here for different reasons at different times. So this kind of go out to just the room as a whole. We may get into the sewer. I know that came up in the last meeting, so I really want to confirm that the sewer isn't going to be overloading the town system that could then adversely affect the neighborhood with backflow into homes or Route 1 or whatever. So whoever can answer that at whatever time. Frontage, I know, has been discussed. I was made aware that the hotel parking, they have 145 rooms, and they started tracking how many of those rooms actually needed to go into the garage with overflow. So they were at capacity the last few days, and I'm not sure with your numbers how that works into the number game. So whatever the stipulation is of what they're able to use, how that affects your 39 overage, when are they being forced into shifting out of not having the resources that are whatever under your agreement with the hotel. And then also this is, I guess, kind of for Sal, like if you're still 39 spots over, what does it take?
Who is attorney? Who's Attorney Neil?
You?
Sure.
Okay. If you're still 39 spots over, like, what would it take to appease that? Like, how much would you have to scale back so that the parking isn't an issue? Between the hotel, between the commercial, the residential, the weird pitch that's on the street, I mean, the entryway. So you can answer that or bank it or whatever you want to do this.
I'll go ahead and answer it now if
Yeah.
that's okay. Sean, you can correct me if I'm wrong, but the agreement with the hotel is for 125
Correct.
parking spaces?
None of which have been counted in October.
Correct. So the total number of spaces that are available in the garage do not include the 125 that are under the agreement with the hotel. Anything over and above those 125 spaces is absolutely available for both the office use and for the residential use, depending on the times. So I don't know, I don't really understand your question about what needs to be reduced.
Well, I'm just trying to get the math right. So they were saying that they maxed out and they had to do overflow into the first floor of the garage. So if that is utilized, aside from that, all the numbers you're using with commercial and residential still puts you a little bit over on the 39 if you were doing the math from the other week.
I think the agreement only allows for 125 spaces.
It's like 25.
Yeah, so anything over and above that is not allowed under
Yeah.
the agreement, so they just wouldn't be able to do that.
All right, so we're still at a 39 window of a bit of a variance from what we were saying the other week.
Well, again, our position is that what's required under the shared parking bylaw is met,
Yeah,
because there is 384 spaces available, only 355 would be required because of the off-peak uses.
well,
But to the extent that the board determines that the shared parking is not applicable, then we would be requesting a waiver of the additional required spaces.
so I guess the concern for me and from last week is that or last month, it's stipulation parking. So there is not 24 hours a day that you have max parking for all people. So if the commercial and the residential were fully on property at one given time, we would not meet our number, I guess is what I'm hearing.
No.
You're doing it by like working hours and supposed.
Well, that's how the
hours.
shared parking bylaw works. So and I think it's, I don't remember the exact hours, actually, I know I have it right here, the 7 to 5 p.m., right? 165 spaces is what is required for the office use
Yeah,
during that time,
Yeah.
which leaves 49 spaces available for the residential use during the period of 7 to 5 p.m. Outside of those periods, the required spaces for the office use goes down drastically, opening up a significant number of spaces that would then be available to the residential use. But only 49 of those spaces can use the office garage parking from 7 to 5.
all right, so I guess I'm just curious what the overflow plan is when those two things collide. It may not be there, but there's always the plausibility that all the people will need resources together at some point, or pretty good percentage.
If I can interrupt, do you understand the 39 bank spaces don't exist right now?
I do.
Okay, so that's the
That's why they were
the
talking
cushion.
about building on the
That's the
side.
cushion.
Right, but
They're
and
just
the
gonna-
intent is not to build
Yes,
them.
yes.
But we can show a plan
But
that
the whole
locates.
thing is-
You don't need all of them at once.
Correct. And just, because of the lived experience with the office, we know that it's incredibly overparked currently, in that they don't come close to using even the 165 that are required. So we don't anticipate there ever being a circumstance where there are more parking spots that are needed for the two uses than are available on those two sites.
God, well. Okay,
Yeah,
just hoping.
so I just want to
Yep.
keep up with that. Mr. Reed, do you want to answer the question regarding the sewer,
Sure.
Oh, yeah.
whether or not the sewer capacity?
Yeah, so if there's one thing that is a certainty is there will be adequate capacity in the sewer line or else we will not be allowed to connect. We've done our due diligence to make sure that there is adequate supply. We'll still have to prove that to Brendan and his team and Todd and his team when it comes time to filing for a building permit. But for example, we have two ways of connecting to the sewer. Part of our sewer is going out an 8-inch sewer that leads from Hockeytown to Forest Street. And then part of our sewer uses the existing sewer pump station that we have on site that was built for the much larger office building that's not being used. So one of the buildings will go to Route 1, the other will go to Forest Street. but both of which have adequate capacity.
And in the event that they don't,
That's speculation that we can't conceive of happening. The only additional thing would be, I would say, is we have what's called a 3-to-1 mitigation requirement. So when projects come online, new projects come online, they have to do an infrastructure improvement project or contribute capital to the town so that they can help reduce the amount of inflow into their sewer system at a 3-to-1 ratio. So in effect, by doing that, we're actually taking out 3 times the amount that we're putting in during peak periods, so I can pretty much guarantee that there won't be any surcharges as a result of our project.
let's go somewhere, okay.
All right, I just wanted to say ahead of things.
Let's see, all right, so this is from a neighbor that's kind of on the corner, Forest Street and Main. She has the easement for the gas line that goes behind her house. So Tennessee has the ability to go there and basically monitor it, maintain it. So it goes through her back property. She's curious and concerning about like,
Now, what street is she on?
she's on Forest, so if you were on Main Street and you took a right on Forest, I think it's like the second house in. So the gas line it's like almost like a power line, wide open, cleared out area between the trees. And it runs behind, and I think actually through her property, to be honest. Vincetti, Teresa. So she's concerned about preventing people from having access to walk down there. And I know we're doing the wall and the fence, but can you fence right across the gas line to prevent people from taking that stroll?
No, you can't, because the gas company maintains, that easement that goes through her property is the same one that goes through the subject property.
Yeah.
And the whole purpose of that is to maintain clear passage for the gas company, to maintain their infrastructure. So we can't put any fences across that, nor could she, I presume.
All right, so potentially walking through. That's a concern of hers, that people could walk through there,
So,
scoot on down.
so a little bit confused on where exactly the home is.
I think I have a picture for you if you want. Google
This
Map
is
it.
similar to the issue with the hilltop location and the gas.
Yeah, but what side of Forest Street?
So when you come up here, here's Main Street and then Forest Street. So this is her house. These 2 houses and there it goes down to that Main Street.
Where's Main Street?
Right here. And then her street, and then, so these 2 houses.
Oh,
that
those
goes
2
like
houses
that.
right there.
See, this would be the
Okay,
project.
those houses, all right. I know, okay.
So, yeah, she has to keep it clear for there to have maintenance, but so she was like, what about people walking through there? I mean, I know it's rocks, but you know, you're gonna have kids,
They're trespassing.
Well, they're more behind,
but there's no way to block it, right? I guess.
but they're more behind the angles and the fence is already up for them. According to that picture, is that the angles fence right behind those properties?
No, they're not that, but it's like the anglers and then the gas line and then their properties along Forest. So I don't know how you communicate that with her, or the 2 residents that are on the corner.
They have a similar issue further up the street by the hilltop property. And in the back of it, there was talk about.
Yeah, the fire road that wasn't a fire road? Yeah,
Right. That has to be kept clear so that they can service the area.
yeah.
You can't block it off or prevent them from accessing it because they have an easement. If someone were to walk on the property and they didn't have permission or the easement,
Yeah.
they would be trespassing, so that could be a problem for them. But you can't isolate the property. If they
So
can't-
maybe even
I
just
think retaining
signage.
walls are gonna prohibit anyone from creating paths and everything else.
But you wouldn't be able to do it because of the gas line, you're saying, like you can't build in that little spot. Yeah, so maybe, I don't know, do not enter sign, like anyone's gonna read it. It just could be a concern for a future, whoever's gonna get that.
Are
Right.
you able to maybe put some type of like larger stone there that's,
They can't prohibit any access. You can't
Any
put.
visual.
The access.
So just for clarification, this is a gas line that runs down the center of the
Yeah.
easement. And what they have is they have a 30-foot clear area that they maintain, that they have to keep constantly accessible 100% of the time. So we can't put a fence across it, can't put a tree in the easement, can't put a rock in the easement. They have to be able to get through that easement at any point in time. Now, it doesn't mean that anybody else has a right to access the property, that's an easement.
You can still prohibit access to the easement.
We could not allow people that do not enjoy the benefit of that easement to not walk there, I suppose, but we can't put up a physical barrier that would otherwise preclude the
Right.
gas company's access. Nor would we put up a barrier that they'd have to unlock or open up. They want to have clear through access at all times.
Okay. That's the thing. All right, I think I'm almost done. So in last, I think it was last month's meeting, there was some verbiage in one of the waiver requests about future access to abutters, and it was vague and plural. And I had brought up to Jesse, I know anything's probable, but I would prefer that actually is very specific to, and I think you already agreed to this, to Forest Street. So for example, in the future, I have a similar scenario I know of in Cambridge, where a building property was able to purchase someone's home after they had deceased because they wanted to add an access. Now I know there's ledge, but there's always refilling and making the possibility to, in the future, add a street that goes right into Forest if someone decided to sell their property off or whatever. So I don't think it should be a big deal, and I think you already agreed to being able to put that very specifically, that it's not just general
Jesse, are you
abutters.
familiar with that waiver that you're talking about?
No, I'm not.
We talked about it last time. It basically just says, like, if it works, you can add access, but it was a very general abutters, and butters plural, and abutters without specifically saying not to Forest Street. And as much as the grade doesn't support it right now, there's always the possibility of adjusting grade, as we've been doing with this project. And I just would like it to be very literal to say, will not have future access in perpetuity to Forest Street in anywhere. Sorry.
So just for clarification, that waiver was a request for a waiver from a requirement to make that type of a connection? So the bylaw in the construction of that particular section that we asked for a waiver was saying that you had to extend connections to adjacent rights-of-way and adjacent properties. So we were saying we wanted relief from that requirement because we had no intention on connecting to Forest Street or any other streets in
So I guess
Shelburne.
I'd personally like the verbiage for the intention to be never, perpetuity, never to Forest. If you can throw, if you don't think you're
I'll leave that
gonna
up to
do
the
it.
attorneys.
Yeah,
We're happy to have a condition that prevents access to forest. There's no intention of doing that at any point. It would
Okay.
basically require redoing the entire site in order to
We
do
have one
that.
further up the street,
Yeah,
so
Okay.
it's the same thing.
but again, it would be no vehicular access. I don't think we can prevent people from walking if they're able to navigate the. Right.
I think I'm almost done. I got the bullet list from everything. What is the time window? So when and if this gets approved and all the waivers are cleared, I know it's a few years to kind of get all the finance and logistics together, but is there a time window where we would expect either start of building or where we would have to then come back to all of this to reassess? Like, is there a cutoff? You must actually execute the project in a certain amount of time when and if it's approved? Or is that in perpetuity as well? Perpetuity? Anybody know? Lawyers know?
That might be.
It's
Something to
2
Google?
years on the building permit, isn't it? So
Oh, yeah, that's probably. After financing?
I'm sorry, is the question how long is the permit valid for?
Yeah,
Well, I think
so,
she's
yeah.
looking for a
So-
timeline. When,
So under the regulations.
like, when's construction gonna start? What's it?
Right, so under the regulations, a comprehensive permit lapses if construction is not commenced within 3 years. It's not quite clear as to what constitutes commencement of construction, whether it's actually pulling a building permit, whether it's committing site work, beginning excavation, things of that nature. I don't know what the exact timeline would be. There is a process that has to be done after the issuance of a permit. You can't simply, once a permit is issued and the appeal period is expired, you can't just walk in and pull a building permit. You've got to, the draft decision has a whole set of things that need to be done, including the submittal of final plans. You also have to go through what's known as final approval with the subsidizing agency. In my experience, it's very, very rare for a project to actually commence construction within 1 year of the issuance of the permit. And that's just how it generally tends to play out. And again, the permit lapses if construction is not commenced within 3 years, but that period can be extended. So the only thing that needs to be done is to file a request with the board prior to the expiration of the comprehensive permit that it get extended for another 3-year period. And that is treated as an insubstantial change request under the regulations.
Okay. Go on, Jared. I think I'm almost done. So I had brought up about the escrow for potential damage, and you mentioned that the blasters would be the one reaching out. And is it that company that is going to hold any escrow for damage? And where would that communication be listed so we know who would have that?
So the
communication?
blasting company will have insurance, and that'll be what would be covering any potential damage.
Okay, so we go through that.
Correct.
I think that's the list.
Well, and the meeting's being recorded, so if you can just state that.
Oh, yeah, Tricia Forestry, Tricia Priestley, Forestry,
What number?
24.
Thank you. All right, you're finished?
Yeah, I think that was all the ones I got.
Yes, sir.
Good evening, Mark Kornitsky. I represent Logan Lodging, the hotel. I just wanted to make one point. I heard a representation that the hotel had done some due diligence about parking. I'm not aware of that. I talked to the principals of the hotel this week, or last week a couple of times. I hadn't heard about that at all. And the point I wanted to make was the hotel thinks it's important that that condition about the 39 parking spots being land banked, and also with respect to the specific condition, the language that Attorney Haverty suggested was, if necessary, that there be some process that's reasonable to determine what if necessary means. I think it should also not necessarily be the full 39 that may need to be necessary. It may not be 0 to 39, but if there's some amount of additional parking that the actual use shows is demonstrated, that it could be the building inspector, it could be this board, but someone has jurisdiction to make that determination that additional parking should be built and secured and how much it should be. And that's my point. Just trying to really pay attention to that condition is what my client is looking for.
Yes, Jose?
There was some discussion on that issue when they were bringing up the spaces, and it was a reference to handicap parking. If the police department determined that more than X number of spaces were being used improperly for handicap parking, that might trigger an issue of requiring additional spaces. So that could be either part of the condition or some determination from the policing agency that if more than a certain number of tickets for illegal parking were issued, then that would trigger it.
Okay, well, the board's paid great attention to the parking issue. I appreciate that, and I'm sure you will as well with the condition, so thank you.
Thank you. Next from the audience? Yes.
Todd Baldwin, Town Engineer, Saugus. We had some draft conditions that we proposed. There were a couple of follow-up questions. I did find the water study, so that condition is, and I've got the review, that's settled. There was a follow-up question about the sewer study. There is, when you go down to Main Street, just past where the CVS comes in, the sewer line goes from 8-inch up to 10-inch. I would like a wet and dry weather flow monitoring in that manhole, because that's, because both of your sewer that comes out the back and the one that comes out the front connect. The one that comes out the front goes to the CVS manhole, connects in. So if there's an issue there, that would tell me that there was an issue. So I guess I'd ask the board to require wet and dry flow monitoring in that manhole, and I can follow up with an email to the board with a plan to show exactly where that is. And that would be what I would use to show, basically see if there was an issue.
Zero objections to that.
Okay.
We would do that as a matter of course of designing.
Okay. So that was the follow-up to the conditions I had there.
And you'll send the email so we get the wording right,
Yep.
please.
Yes.
That's Jesse, yes.
It goes to the board, but Jesse gets included in it, and Jesse will help us all make it appropriate.
Through you, Mr. Chair, just to confirm, the condition that you mentioned being settled, which
Sorry, that was the water-related one, which was condition.
That's 9.
Yes, number 9. There was a study that had been done in the past. I'd reached out to CDM.
Yep.
They sent it back over.
Okay, so we can delete that.
Yes.
Todd, if you could just provide the manhole number for that.
Yeah, I'll actually, I have a map. I'll circle it or highlight it and email it out to the board, including Jesse.
As long as Jesse gets the.
Yep. Well, officially, it's going to the board
Yeah.
and including in Jesse, and I'll make sure you get a copy of it. It's basically like right there.
Okay.
Because you come in from there, and you come in from there, and it's an 8-inch still there. It goes up to 10 there.
Yep.
So if we're going to have a problem, that would be where the problem would be.
Understood.
So again, through you, Mr. Chair, the plans you've got there, Todd, that indicates the manhole that you're referring to?
I'm going to circle
You
it.
can circle it?
Yeah, this is an atlas of the sewer system for the town.
Yep.
I was using that to kind of figure out where we would have the most likely place to have a problem.
Okay, I'm asking because if the hearing closes tonight, the board can't accept any additional evidence.
Then you know what?
Provide that for the record now, that would be ideal.
Isn't it just manhole, manhole number right there? Just covered up?
Well, how do I submit it?
Just hand it over to Tom.
There you go. And I can, so now it's official, but I can do something a little bit better tomorrow or well, whatever is appropriate.
Okay.
We'll know what we need.
I know.
That was my only comments.
Todd, before you go, I had a couple questions for you before you go away.
Oh, afterwards or what?
Seems like comments.
Yeah, I just wanted to suggest, a condition that, as suggested by the town engineer, the applicant provide wet, dry flow monitoring as, stated, by the town engineer, and that the applicant shall have a discussion about the appropriate location for that. Just something that sort of encompasses what is said without necessarily being as specific, because that specificity would come afterwards. But you certainly can have a condition that requires the applicant to meet with the town engineer and identify specifically where it's going to go.
Yes. Just through you again, Mr. Chair, just a couple of questions about your conditions.
Yep.
Number one, if you could discuss what you have in mind, or so that we're accurately capturing this in the draft. The developer will need to fund a study to ensure the town system can handle the additional flow and any improvements required by the study will need to be paid for. You're looking for a sewer flow analysis?
Yes.
Okay. And then, number 7, developer will create a checklist of fees and when they are to be paid for use with this project.
In past projects, projects of this size get very, very complex. And I specifically have had one project in the past where the developer actually went through the conditions of the board and they made an Excel spreadsheet with a checklist of before building permit, these are required. Before occupancy, these are required. Before all the different sections, and it's an administrative task. I found it incredibly useful, and I would love to see it in every other project going down from now. And that would be something that the developer, it's an administrative task that I feel the developers should be doing, which will help the town keep track of all conditions, making sure all conditions are met and fees are met before, so like before occupancy, there'd be a checklist of, did they do all the conditions that are in there? I visualize that a checklist is easier to check for me personally than going to the decision, which is actually the legal document. It's just one leads into the other.
Anyone else in the audience? Yes,
Sorry, I was just wondering, I know.
you need to come to the board.
Sorry.
Thank you. And just state your name and address.
Sherry Rust, 11 Breakheart Road. I was just curious, I know they discussed before that with the blasting, it was gonna be a 250-foot radius.
Now it's 500.
Oh, it is?
change. 500 feet, but that's from the spot of the blast.
Okay, I was not
I
aware of
don't
that.
know.
I'm on Breakheart, so I'm not
And
sure.
I know the area very well, but I don't know if 500 feet is gonna take in your house. I'm not sure.
My question is, just so that I'm prepared, because it's
Yeah.
a very densely populated area where the blasting is gonna be.
Right.
If I fall 525 feet away, what recourse do I have for any damages that are done to my property? I mean, for 20 feet, if my foundation is cracked or I have structural damage done to my house, do I go through my homeowners? Like, what recourse do I have? Just so that I know. I don't.
Sorry.
So in a lot of ways, the pre-blast surveys are really done to protect the blaster, more so than the people within 250 feet of the blasting, because what it does is it gives them the opportunity to go in and survey the condition of the houses in that area and see what the current problems are. And then when they do the blasting, they can go back and compare and make a determination as to whether anything has changed. The fact that you are outside the 250 feet, or in this instance, we're agreeing to do up to 500 feet, doesn't mean that you don't have any rights against the blaster if there is damage that you are able to prove was caused by the blasting. But it's really just an issue of proof at that point.
Okay, but if I can't have the company come out because I don't fall within the 500 feet and they can't come out and survey my home before the blasting, do I have to incur the expense to have an outside company come in and inspect my house as protection to myself if something happens?
That would be an option that you could do.
Is that the only recourse I have?
Well, again, you would always have the recourse to go after the blaster, go after their insurance company.
But if I don't have proof prior, I'm gonna lose.
Well, it depends. Again, a lot of the purpose of the pre-blast survey is to protect the blaster more so than it is the resident. And it's so that you can document the current conditions. If you want to document your current conditions, you certainly have every right to go around and video, your current thing, date stamp it.
Right? If I can interrupt for a second.
Sure.
If you're gonna do that, you should be using the same company, not a different
Yeah,
company.
that's fine, yeah. I'd be willing to do that.
Yeah, and again, you could do it yourself, you could hire a company to do it for you,
But I would recommend the same company,
and that's definitely helpful,
if that's an option.
yes.
Okay.
That way we'll hold some weight. And you don't have an idea what that cost would be to you as an individual. But if it's 500, think of it, it's 500 feet from where the blasting site is. So it might be 250 feet before you even leave the property.
Right.
So I just think it's unlikely gonna carry much farther than a few homes on Forest Street. Might go to both sides of the street, but I don't even think we'll get as far as Breakout.
I hope not, but,
I'm just saying the 500 feet won't.
yeah. But we've felt it on Oaklandvale with blasting at McDonald's. And I know they didn't have a gas line going through it, but still, for that to travel on the other side of Route 1 to Oaklandvale Ave, and my parents' house to shake, and I live the street next to them, it's just concerning to me. It's just concerning. I just want to protect myself, that if something happens to my home, that I have a way of fixing it.
Mr. Chairman.
You certainly can go through your home insurance. What I would do if I were you is take a lot of pictures, walk around the property, take a newspaper, get the newspaper in the picture, show your foundation, whatever areas you think might be an issue. And you could certainly put in a claim against your insurance company, and they will go after the blaster.
Thank you.
Yes.
I was just gonna say that I think it is important to know where the gas line does go through the property. The charges are gonna be much less than the ones that were across the street. Therefore, they won't travel as far.
Well, gas line is across the street too. It
At-
travels across the street.
At
It's not far
McDonald's.
from, not far from McDonald's and Shore.
Okay,
We had to deal with in the ridge. We had to deal with the gas line being right there.
okay.
Just to clarify, is the 500 feet to the property line or to the structure itself?
From where the blast,
From the blasting, but
from the,
to,
in the blasting area, that's what I said, could be in the middle of this property.
right,
And then
but
it could
if,
be 250 feet to get outside the property.
but 500 feet from the blasting zone, if that hits my backyard, does that mean that my house gets surveyed, or does it have to be 500 feet to my house to get surveyed? Like at what, is it just to the homeowner's property or to the structure on the property itself?
Through the chair, to the structure.
Thank you.
Thank you.
So it might go to my backyard and like hit the shed, but not the home itself.
Correct.
The home has to be within 500
Correct.
feet.
Anyone else from the audience?
Briefly.
Yes.
Sure, I'm Matthew Sherman, president of the Malden Anglers, 227 Main Street. Like to thank everybody for listening to us. I'll be brief. I've turned in all of our comments, or in the letter submitted July 14th to the entirety of the board, to Stephanie, the chair of the board, and council. We're copied on all of those. We stand by those, and they're for your use. All of our comments are in there and summarized. The two I'd just like to call attention to, the main concerns are with two of the proposed waivers. The first one was to Article 5, Section 5.7, the Environmental Performance Standards. That's the section, that's not just a construction time it doesn't just rely to the time of construction, that's in perpetuity. That's to protect the neighbors against all the environmental standards or potential risks. So the original proponents' conditions asked for that to be waived in its entirety. We don't feel that waiving the environmental standards, Section 5.7, in its entirety for perpetuity is appropriate. That's the first one of ours, and I know the city engineer, remember the city engineer commented that would be atypical. You may want to ask that back to the city engineer while he's still here. The other main concern is...
Sorry to interrupt.
Sure.
Just
Let's
while
do
we're
one
on
at a
that.
time.
We did get Mr. Baldwin mentioned that last time. He would recommend that we do not waive environmental performance standard, Article 5.7.
Okay, we'll have a comment. Sure.
And then-
Before you go into that, Mr. Ball, would like to comment? You stick with that.
No, I stand by my comment, but I believe you guys took that off the waiver.
It's not on our current waiver.
Yeah, the waiver list, the waiver.
Oh, you removed that from the waiver list anyway.
So I
Portions of
believe
the
that's-
design standards.
Well, that's up to them.
All right, see, we have no way of knowing that because it wasn't publicized.
That's
Yeah.
okay.
So we have no way of, so
It's a
I would
learning
keep that
process.
off of the waiver
It's a
list.
learning process.
I would keep that off of the list. It's been
Okay.
very difficult to keep up to speed on those. And the other one is just to call your attention to is that the requested total waiver of Article 3, Section 2.B.D.7 and Article 3, 2B.O. Those were related to stormwater and asked to be waived in their entirety in the sections that we had. We think those are actually very important as well. Those are fundamental to the health of the downstream properties, one of which is us. So we're asking that those not be waived. We call your attention to that and ask that they not be waived. There was a letter from a hydrologist in support of not waiving that we submitted priorly from Mr. Horsley. so that we ask that that not be waived, and we included some alternate, some suggestions on how that condition could be better approached. So those are in the letter that we sent over. And
Mr. Red, do you want to address that?
well, aside from that, we're just going to stand with what we've submitted. We request that that go to the town, and we'll stand behind Mr. Horsley, who's a water resources consultant, who's well-known for these types of actions.
All
All right, thank you very much.
Thank you. Mr. Red?
What we did is in response to the objections to the blanket waivers, we went through and compiled a new waiver list, which was very specific. There were only 2 stormwater-related waivers that we requested. One was for a waiver. One of the regulations in the bylaw requires you to surround your detention ponds with a fence or a hedge. As a professional engineer, I don't like to do that because it hinders maintenance of the pond, and it's also a hindrance to emergency responders if they ever need to get into there. So if a child gets in there, the last thing we want is something preventing that child from getting out or preventing someone from getting in to help them. So we asked for a waiver of that, which was just basically for a perimeter control around the pond. And the other one is for a requirement for a 60% phosphorus reduction. On this site, with it being all rock, there's almost no chance for us to infiltrate, and infiltration is typically the only way to reduce phosphorus. What I can say is that because our project is developing a site that is heavily wooded or has a lot of sort of leaf litter and things like that on it, in all likelihood, our project will end up resulting in a reduction in phosphorus naturally as it relates to how we manage the site. So we're asking for a relief from that requirement. And then that would be, I would think, something that would be normally granted as a waiver during the process of working it out with the town as well.
Do you want to reply to that?
Please. I just note that regarding the phosphorus, that's one of the key components that relates to the pond health, and that is specifically addressed in Mr. Horsley's letter. The proponent that it's improbable or not practicable is specifically addressed in the letter. I'm not an expert on that, but our consultant was, and he specifically addressed it in his letter and talked about how that requested waiver is not applicable. So we'll stand with Mr. Horsley's letter. Thank you.
Yes, Mr. Baldwin.
So the request for the waiver about the fence, I have no comment or opinion about. As for the phosphorus removal, it might be premature to be waiving that. It might end up getting waived, but we're not that far along into the project yet. I guess I think it might. My opinion is it's premature to waive phosphorus removal. In the end, it might get waived, but there's a bunch of steps to get to before we get there.
Any reply, Mr. Red, to that? Part of the attorney?
Yeah, the only thing I would say is that this is the only time in which the board addresses waivers. You can't go back and you can't grant a waiver that's like a springing waiver. Either you're granting the waiver or you're not granting the waiver. We would certainly be open to a condition that requires us to have further discussion, with the town engineer to see what additional options could be. But we would request that the board grant the waiver, but include a condition that requires us to have further discussions with the town engineer.
Does that sound satisfactory, Ms. Paul?
Yeah, what I'm saying is that now is the time for the board. They have to have all of their decisions as part of their decision. So that includes the waiver decisions. But we would certainly be open to a condition that requires us to work with you in your office to address this issue, and potentially we could eliminate the waiver if it turned out it wasn't necessary.
So my experiences with planning board projects, not 40B, is part of working through the stormwater permit would give us the answers. Going through the stormwater permit is the way to, both with the state and locally, is the way to determine whether or not that you should or that you should have relief from the phosphorus.
Okay. So the comprehensive permit decision is the stormwater permit for the local. So the only additional permitting would be under the Wetlands Protection Act.
So, I guess.
But we're happy to have a condition that requires us to come back and have a discussion and see if there's a way that we can address your concerns.
For most stormwater stuff, we actually have a consultant that this is very complex. And that's part of going through the stormwater. I get that do they have to go through the stormwater or not? They don't have to, right?
So through you, Mr. Chair, so the comprehensive permit that the board issues grants all local approvals that's required. The procedure that the applicant will be required to follow after the board's review is complete is the applicant will advance their plans to final construction documents that are ready for construction of the project. They'll file those with Todd's office along with a copy of the comprehensive permit as evidence that the board has approved the project under the stormwater bylaw. And that will lead to the ministerial issuance of the stormwater permit that they need. It's not a complete full review, but they'll have the opportunity to review the final construction documents to confirm that they're in compliance with all requirements that have not been waived by the board, as well as state and federal requirements.
I was going to say, I'm pretty sure there is already a draft condition that requires compliance with the state stormwater standards, but if there's not, I'm sure Attorney Schomer can draft something that will satisfy the board.
So in case that wasn't clear for Todd, so you will have an opportunity to review the final plans when they're prepared. They'll be filed.
Okay.
And an opportunity to have them
Review by
third-party review. Yes.
Third party? So that would be included within that?
Yes.
Okay, that pretty much follows the process. then.
Yep.
So the waiver stays in,
The waiver,
but there'll be language saying there will be review.
they haven't requested a waiver here. It's not really a waiver. The board is granting an approval of that permit.
Well, but we are requesting a waiver of that specific provision of the
About the
stormwater
phosphorus.
bylaws, about the phosphorus, correct.
So they're requesting a waiver of the phosphorus requirement. The review, Todd's office's review is being done essentially in the first instance by this board. And the approval is being granted by this board. But he'll be the reviewer for the final plans.
So we have it reviewed, and our consultant's saying that they should be able to meet the phosphorus requirements. What happens?
Then,
I think
at this point, the board, if you're granting the waiver, then that issue would be resolved. The board would have already granted that.
And it wouldn't be necessary because your consultant is stating that we're meeting the phosphorus requirement. So ultimately, even if the waiver had been granted, it's irrelevant because what is being proposed would meet it. So you wouldn't even need the waiver anyways. So the only circumstance, where you would have a concern would be if somehow there was a determination that we complied with the state stormwater management requirements, but didn't comply with your local requirements without the waiver.
Okay. I guess my point, or my key thing is that, so we're waiving on a local level the phosphorus, being required to meet the phosphorus requirements, but that doesn't mean anything on the state level.
Correct, the board doesn't have the authority to waive any federal or state requirements. It's already local. So I think to make a fine point on this issue, if your recommendation tonight is that the board deny that waiver, you should let the board know so they can take that into consideration when they deliberate on the decision. And we have to decide tonight whether that's going to be your recommendation or not.
I'm recommending that the board does not waive the current program.
Okay. So what's the solution, or if they don't waive, what's the solution to the developer?
It actually would be following along the normal process. I mean, you guys are gonna design a stormwater, it has to go through review at both the state and the local level. And if you prove to us that you can't meet phosphorus requirements, then that would be something, if you prove to us you can't, we would do what we would follow through that process.
So the regulation as written does not allow for that. The regulation as written says 60% phosphorus removal. There is no qualification, there is no opportunity for discussion with you and a reduction through your review. So and similarly in the Massachusetts stormwater standards, there's all sorts of criteria for when 60% phosphorus removal applies, and all of them wouldn't apply to this site. So the issue is with the way the requirement is written. It's written that must remove 60% of phosphorus. So we're asking for a waiver of that requirement so that we have the latitude to work out a practicable solution with you, as would normally be the case.
So, would you say that on the state level that there's no, or in the local level that we're saying that you have to meet the 60%?
You have a local, a regulation in your stormwater bylaw that says must have 60% phosphorus removal. Doesn't say net phosphorus removal, doesn't say anything more than that. What we're asking for is a waiver from that we consider I think, unintended, overly restrictive requirement, because it's not at all consistent with other similar phosphorus removal requirements. So we're just asking for a waiver from that specific requirement. Does not mean that we're not willing to do phosphorus removal as part of our design, and we will have to look at that as part of compliance with the stormwater standards for Massachusetts. So we're just unable to commit to doing the 60% because we don't even know if it's possible.
Side note for personal, is there a chance that that's an artifact from an older version of the permit?
I think, honestly, I think it was a throw-in at the end, because it's one of the last ones. And they have 60% phosphorus removal targets in certain places and in certain applications, but would not be in this application.
I'll need to follow up on that.
Yeah.
I guess I'm changing my opinion to being in favor of the waiver.
So just for background, phosphorus is a contaminant in stormwater, and it's become sort of a recent thing. And it's managed as part of the state level requirements, and it's managed as part of sort of things that when you have impaired water bodies and things like that. In this case, the 60% phosphorus removal target is the highest required target removal under the stormwater regulations. In the regulation is written that's the minimum standard. So our request is to relieve us of that obligation to meet that as a minimum standard, and instead to allow us the flexibility to address it through the Massachusetts stormwater standards.
All satisfied? Thank you.
I just want to flag to the board that it's not just phosphorus we're talking about. It says the request, at least the version I have, a waiver from this requirement that requires, among other things. It's a waiver from the entire requirement that it requires, among other things, total phosphorus. When you actually look at what's in your code, what's in your rules, included in that requested waiver is not allowing new stormwater conveyances to discharge untreated stormwater, controlling peak runoff rates, recharging groundwater in accordance with the stormwater handbook, eliminate or reduce the discharge of pollutants from land uses, protect zone or interim wellhead protection areas, implement long-term maintenance practices in accordance with it, require that all stormwater management be designed to retain it. So it's total suspended solids, remove 90% of total suspended solids generated, and total phosphorus. So it's not, we're not just talking about, we're talking about removal of an entire section of your stormwater requirements. So you can talk about phosphorus, but they said among other things. So those other things are important, and I ask you to just double check and read your own rules. Thank you.
Mr. Chairman, we're happy to limit that waiver request to simply the phosphorus issue. The other things weren't something we were seeking relief from anyways.
Okay. Mr. Wobble?
I know I personally had some problems getting the up-to-date waiver list. I think you might be working on it.
We work with what we have.
No, I know, because I had similar issues that I brought up. The most up-to-date waiver list I have is limited.
That's correct. It's limited to phosphorus.
Yeah.
Mr. Chairman,
Yes.
We received 2 links, I think, in the previous meeting from the petitioner, with digital versions of everything we were presented. Those links are no longer active. I'm not sure after tonight if they're able to be active, but maybe, I would honestly prefer a digital version over a paper version. It would just make life quite a bit easier. So if we can reactivate those links, or is that against us closing the hearing tonight?
Just to make sure I understand, are you referring to the documents that Lynn sent?
Yeah, we had 2 links. When I tried to open them this evening, they said that they were expired.
Okay, I should have copies of all those, and they've submitted all of those documents for record, so there's not an issue with public hearing.
Okay.
She was sending you a link to everything in one place.
So I never downloaded them. I thought that that was going to be a directory that we could access.
Yeah, I can forward that. I can send that.
That would be ideal.
Yeah, Lynn's links, they usually expire within a couple of weeks, so I just download.
I wasn't aware. Yeah, I wasn't aware of that.
Yeah.
Thank you.
No problem.
You know you want to speak, thank you for being patient.
No, hey, no problem, thank you. Just 2 seconds worth. Thomas Lewin with Mullen Anglers on 227 Main Street. We just wanted to be very careful on waiving that stormwater, and I think Matt said it very correctly. If it's only phosphorus that we're working with, we can work with that. The other thing was, I just wanted to remind the board that this is a closed pond, so as chemicals go in, there's no really way for the chemicals to lead out. So if you are waiving that in perpetuity, if phosphorus or any other chemicals get into that pond, by the time we have a chance to discuss a remediation plan, it may be all over for the ecosystem within the pond. Also wanted to remind them that we had a provision in there asking for non-salt ice removal or snow removal chemicals, and if that was added, and was that being considered. Other than that, thank you for the board's attention. I really appreciate you giving us a voice in this.
And I know the salt thing was addressed as a safety concern. Mr. Reed can talk again, and that they can try to limit it, but there's sometimes they're gonna use a portion of it.
And a non-salt substitute is not possible?
I'm sorry.
Actually, we provided a condition to Jesse that said we will use exclusively non-salt based.
Oh, yeah.
Except that in emergencies or when required for public safety.
All right, so if you had to get a fire truck up the hill or something,
Yeah,
you'd be throwing salt on it.
And if there's a rush on calcium chloride, or if for some reason we can't secure other materials, we want to have the ability of concern for maintaining safety to be able to use salt without violating the permit.
Okay, I understand that.
Yep.
Okay, good,
Thank you.
thank you.
Anyone else from the audience? Anyone else from the board, any other comments? Mr. Rossetti?
Yeah, is there a difference between the town standard for phosphorus and the state standard?
I'm going to have to look into that.
Okay. Okay, I wasn't aware there was.
Yes, significant differences, yeah.
There is?
In the applicability of it.
Okay.
Yep.
So is the town higher or lower?
The town is more demanding.
More to do?
Yeah. What the town's bylaw does is it ignores the whole section about qualification for requiring phosphorus removal, nor does it address net phosphorus removal. So phosphorus is omnipresent in your site anyway, so we have phosphorus going down the hill generated from the leaf litter that's on that side of the hill that falls from the trees. That's a phosphorus generating element. So the state stormwater guidelines tell you what kind of soil conditions you need to have in order to require phosphorus removal, what kind of situation you need to have. So there's a lot more guidance and a lot more latitude in terms of how it applies.
Thank you.
Anyone else from the board? Anyone else from the audience? Attorney Sherman, if you can just go over a little bit on our timeline from here, what our next steps are?
So if the board closes the hearing tonight, that starts the clock on a 40-day window of time for the board to deliberate on the conditions, deliberate on the request for waivers and the wording of the decision, comprehensive permit decision. It's my understanding that the board would like me to take the laboring war of drafting the decision for you
Yes.
I'm happy to do that and then provide copies to the board members for discussion at a future public meeting. The parameters of that meeting would be such that it's open to the public, but it would not be open to public comment or testimony or questions. So it's essentially a conversation on live TV between the board regarding the conditions that I drafted, and I'll be here to answer questions for you. But there's no additional evidence that could come in from the public or from the petitioner in that forum. So it would essentially just be discussing how you want the decision to be drafted and what you want it to say and what you feel is appropriate in terms of conditioning the project based on the testimony that you've received during the course of the last 6 or so months of public hearings.
So with that said, if you got anything to say it now, because you won't be able to say it afterwards. Yes. Your name and address, please.
Ryan Duggan, 13 Breakheart Road. I, far earlier in this process, wasn't able to make it to some of the meetings just due to my schedule, so I'm appreciative of these continued ones that I am able to attend. And I had submitted comments through email, and I never really heard anything, and I wanted to make sure. I sat down and I wrote a nice, well-organized page of paragraphs, and I just wanted to make sure it didn't go nowhere.
I don't remember seeing an email from you personally.
Okay, because part of why I haven't gotten up to speak as much is because I have said, well, I put everything in the document that I sent. I sent it through, I think, Stephanie, I don't remember exactly because it was months ago at this point, but I just didn't want, when you said sort of like, speak now or forever hold your peace, wanted to make sure that mine wasn't just floating off nowhere.
Well, I apologize if your questions or comments go.
I think we got that.
I believe I read that.
It's very familiar.
That was maybe 4 months ago, I believe. 3 or 4 months ago.
Probably about that.
I believe we did receive this.
Yeah, Stephanie forwarded this on
And we just kind of,
February 26th.
So did you read it?
5 months ago, yeah, I read it. You read nothing the thing you read.
Yeah. Speaking for myself, I read it. That's why I can remember it.
Thank you. I made it very memorable.
Yeah, I remember.
Thank you.
It was right. We have received a number of letters, not a huge number, but more than a few. I know we've read them.
Okay, I just wanted to make sure so that that stuff was included in any decision-making
Yeah,
process.
we've read them, and a lot of the things we've sort of dug up for the past several months in the last meeting or two, so that we can basically have some sort of a verbal commitment with the applicant that, we're gonna add conditions, and they're not gonna be completely foreign to them if they see them in 40 days.
Mm-hmm.
So, and that's much of what you're seeing here tonight. Yeah,
Thank
you
you.
got it.
Yes,
Sorry.
Of course.
So some of the neighbors that are in my area were asking, the ones that couldn't come, they were asking where to send those emails to. Like, can I go back to them tonight, even though we're trying to wrap this up, and say, this is the email to send those to? So that you guys have that for this evening, tomorrow, whatever, for their concern. Like the woman with the gas line concern, I just happened to get hers in my pocket, but
Well, the hearing would
when we
close
close the
tonight,
hearing, Jesse, we can't take any more evidence.
but the extension goes to tomorrow for our last discussion, doesn't it?
Yeah. The extension does go through tomorrow to close the hearing, but once you close the hearing, no additional evidence can be taken. I think it's,
well, I think their topics have been brought up.
yeah,
But
that's,
they just may want to just have, like you said, like have that information in someone's hands so it's on record. I don't know. I'm assuming because there's been a handful that, for various reasons, haven't been able to physically attend. And I've been trying to filter in their information and questions, but I think if they could just get it into an inbox. Because I went on the town site, I couldn't find an inbox that seemed to apply.
I just want to clarify, although the extension goes until tomorrow, the board needs to close the public hearing tonight because there is no time for it to continue to tomorrow because you would not meet the 48-hour posting requirement. So the board does need to close tonight.
I think to be responsive to the neighbors' concern. I would say that her friends and other neighbors' concerns have been very adequately voiced by you and by others. So I think the board has a lot of testimony on neighbors' concerns about the gas line. So while the board can't accept into the record any additional letters that come in after you close, assuming in the next few minutes, their
I don't
concerns
think
have
we
been
missed anything. Yeah.
expressed.
It's just whether or not you want to. Digital thing.
Motion to vote.
So I guess all that's left is a motion to close the hearing.
So moved.
Second.
Motion's made and been seconded. Mr. Northup?
Yes.
Mr. Riley?
Yes.
Ms. Romano?
Yes.
Mr. Rossetti?
Yes.
And myself is yes also.
So then at this point, Mr. Chair, what you would want to do is schedule your next meeting. This will be a deliberative session of the board. But we should continue with the practice of announcing the continuances in this hearing so that you don't have to, well, I guess you wouldn't have to republish it, it's not a public hearing. But best practices so that everybody's aware of the next date would be to decide tonight what the next meeting will be. It can be your regular scheduled meeting, but just keep in mind the 40 days. That can't be extended unless the applicant agrees to it.
Would that be dependent on the work that you have to do?
It would, I'm gonna need a little bit of time, so I would say.
What kind of time do you think you will need?
I wouldn't want to meet again for at least a week and a half.
Oh, yeah.
I need a little bit of time to have a draft for you. But beyond that, I'm not
Well,
sure.
our regular meeting this month is the 28th, I believe. It's Thursday, the 28th.
That's more than, I can get you a
It's
good
over
draft.
3 weeks.
Yep, I can get you a
Um,
good draft in advance of
And
that.
I don't think that push, we don't have a lot on the agenda as of right now, I don't believe. And I don't think that meeting should take a real long time. Like you said, all people, everyone can come in, they can sit in the audience, but they can't participate. And that includes the petitioner. So it's just the board and you, and that's it. And that 28th is good for you,
It's good for me, yes,
okay?
if that's good for all of you.
And we will, even though not required, we will post it. At this point, I do want to sincerely thank all the neighbors that have come out for over 6 months now. And no matter which way this goes, I want you to understand your input was heard. And, you know, regarding buffer zones and trees and lighting and everything else, it was all heard. Everything the Angles had to say has been heard. It was, you know, I appreciate Mr. Baldwin coming out. We don't see any other department heads, as I've mentioned before, and I really appreciate your presence. I want to thank the petitioner for the way they carried themselves. And thanking, and the professionals that are with them. And I think that's about it. Have a motion to adjourn?
So moved.
Okay, seconded?
Second.
All right, adjourned.
Thank you, Mr. Chair, members of the board.